Yes, welcome to everyone. So I'm Alison Cairns and I'm welcoming you here on behalf of the MGAA. So yes, today's session is being delivered by Render. I'm going to run through a few quick housekeeping bits and pieces and then do some introductions for our presenters and hand over to you. So few things to make you aware of and polite requests is, can you please keep your microphones and cameras off, because actually we have got quite a large number of people here today, so it helps with the technology if we keep cameras and microphones off. If you have any questions, there will be opportunities at the end of each section of this session. So please can I ask that you pop them in the chat, and I'll keep an eye on the chat and we'll ask them at the various different points where they've got the opportunity. So please add those questions in as we go through the session. Other thing to make you aware of is that our programme of learning and insights is accredited by the Chartered Insurance Institute for the quality of the content and the supporting material. So this does mean that CPD hours are available for you to add if they are supporting your ongoing professional development. Last thing to make you aware of is that we are recording the session today, and afterwards it will be available after a short period of time. We will upload it onto our website and it will be available on our the MGAA YouTube channel. So one last thing before I hand over is there's a feedback survey which I will pop a link to in the chat, and yeah, it takes no more than 2 minutes to complete, and all of your feedback is very much appreciated and helps us shape these sessions in the future. So without further delay even, I will pass you over to Render, who we have Alan, Ben and Chris here, and I will leave them to introduce their session and themselves. So over to you.
Thanks, Alison. So good afternoon, everyone, and thank you for joining today's panel discussion on commission disclosures in premium finance. We'll start with some quick introductions and I'll provide an overview of what we're going to be discussing today before diving into the session. So to kick off, I'm Chris Rees. I head up premium finance for Render. For those who haven't heard of Render, we're a member of the MGAA. We're a disruptor in the kind of the insurance payment space, offering both premium finance and card payments. We place a strong emphasis on technology, using the same type of payment technology that Netflix and Amazon Prime use, allowing businesses to fully operate their payment operations processes. And yeah, we've been in the industry now for a good while, and we're just getting set up, and hence why we've joined the MGAA. And I will now hand over to Alan, who is the chief, who will introduce himself.
Thanks, Chris. Yeah, my name is Alan Cathcart. I'm the Chief Compliance Officer here at Render, otherwise known as Finter Limited. And you may have seen we also make unsecured personal loans under the brand of Abound. I've been with the company for just coming up for 5 years. Before that, I was at HSBC for a number of years. Before that, at the Financial Services Authority. Before that, at the Bank of England. So a long career in finance and regulation.
Afternoon, everybody. I'm Ben Player. I'm a consumer and fintech lawyer at law firm Osborne Clarke. I advise across multiple sectors, including financial services, retail, and TMT. Osborne Clarke is a full-service international law firm, and we really specialise in providing strategic advice to our clients across our specialist sectors. We've been providing our lender clients with advice in relation to the decision in Johnson Wrench and Hopcraft really since it was handed down at the end of October 2024, and providing advice in the run-up to the Supreme Court hearing, which will take place during the course of 3 days next week.
Right. So I think everyone's here for kind of probably a sound understanding of what's been happening in the market and what's been happening in the most finance sector, and how commission transparency under intense scrutiny has become increasingly clear that there's challenges and regulatory shifts that could extend to the premium finance market as well. And in today's sessions, what we're going to explore is the implication of the motor finance commission scandal, the legal precedents set by the Court of Appeal, what this might mean for premium finance, lenders, MGAs, brokers, and consumers. In the session, we'll be starting with a quick overview of what's happened in the motor industry, how it came about, the legal and regulatory response from the Court of Appeal, what's going to happen with the Supreme Court, and what this will look to mean for the premium finance space, how brokers, MGAs can look into deal with commission disclosures, and the future outlook for the industry. So in terms of some housekeeping around the sessions, we want this to be pretty interactive. I'm sure everyone will get bored of our three voices eventually. So at the end of each topic, we'll look to have a quick Q&A round for about 5 minutes, where if people have got questions around that subject matter, we can kind of dive into more detail. I'll kind of quickly outline the subject at the start of each one. So feel free to add questions to the chat, and then we'll look to kind of go through those and maybe pick out 1 or 2 questions as we go. Great. So to get started, I think the best place is obviously looking at what's happening within the motor finance space and what's happened. Obviously, this all broke out last year. I think, Ben, maybe your best place to start with, like, what are the kind of primary factors that led to the Motor Finance Commission all coming into play as it is today?
Yeah, sure. So in terms of kind of origins and developments, the decision in Johnson was an appeal from 3 cases, a combined appeal: Mr. Johnson, Mr. Wrench, and Miss Hopcraft. 3 customers described by the Court of Appeal as vulnerable and unsophisticated. They all visited motor dealers to buy second-hand cars. Those second-hand cars were funded by credit provided by third-party lenders, and in each case, the lender paid a commission to the motor dealer. The circumstances regarding the payment and the commission model varied between each customer. We had fixed commissions. We had what's called a difference in charges commission, so a discretionary arrangement that has now been banned. And there was also a real mixed bag in terms of what the motor dealer's paperwork said in terms of disclosing that commission. So some said we may receive a commission may be payable, and where those disclosures were contained in the relevant terms and conditions or customer journey varied as well. And that was all apart from Miss Hopcraft, where there was no commission disclosure at all, and that was accepted by the lender. That is the factual background and matrix to how we are here.
Excellent. And I think that's kind of led us quite nicely into what is kind of the Court of Appeal's view on those items, and what is the kind of the next steps that the Court of Appeal feels is right by the consumer.
Sure. So in terms of what the Court of Appeal decision says, the Court of Appeal says that the first thing that you need to do is you need to characterize the relationship that is between the customer and the broker. And in an insurance context, that's the insurance broker. In the Johnson decision, that was the motor dealer acting as the credit broker and the seller of the vehicle. What the Court of Appeal said is that where you have a fully undisclosed commission, so what's called a secret commission, where the broker owes a disinterested duty, and a disinterested duty will arise in circumstances where the broker has a duty to provide information, advice, or recommendation on an impartial or disinterested basis, then what needs to happen is that, well, where there is a disinterested duty, a broker cannot comply with that disinterested duty unless they make it abundantly clear that they can't act impartially because they are about to receive a financial reward. And what happens is that where commission is paid without disclosure, then the lender is primarily responsible as the payer of a bribe, and that the customer has a remedy of rescission, so cancelling the credit agreement and the repayment of the commission. Where there is what's been called a half-secret commission or a partial disclosure, where the fact of the commission has been disclosed, but not the amount of the commission, then the Court of Appeal says that in order for there to be a remedy for the borrower, there needs to be what's called a fiduciary duty. And the Court of Appeal in Johnson said that the fiduciary duty arose in all three claims in tandem with and as a consequence of there being a disinterested duty, and that arose from the nature of the relationship between the broker and the customer, the task which the broker motor dealer was entrusted with, that was sourcing the lender, and the duty of loyalty that goes with that. And so the court said that the brokers had a duty to source and select competitive terms, and that the customers placed trust and confidence in the dealer to do that. In those circumstances, the dealer needs to obtain the customer's informed consent to the payment of the commission. And what amounts to informed consent, the Court of Appeal said, was the specific amount of the commission, the basis for its calculation, and the tie between the broker and the lender. And if that doesn't happen, then the lender is liable as an accessory to the broker's breach of the fiduciary duty, and there are equitable remedies available.
Great, thanks, Ben. Yeah, it's an interesting stance as well, because it flies slightly in disagreement with what the FCA had in principle before this kind of all came through. I suppose, Alan, from your perspective as well, obviously being quite close with the FCA, how is the FCA, do you think, looking to progress forward now that the Court of Appeal has kind of come out with this announcement? How do you see them kind of progressing with how they look at commission disclosures over the next couple of months and years?
Well, I think it's fair to say that the judgment came as a surprise to certainly to the motor industry, but also to the finance industry more generally, as people look to see whether there are the judgments, the extent to which they can or cannot be extrapolated from the motor finance industry to premium finance, or indeed even to regular lending. We can perhaps touch on some of those in similarity with premium finance arrangements later. What this clearly does is put the question of commissions firmly on the FCA's register. I think that a lot of people thought that they were complying with the rules in CONC around disclosure of commissions, and maybe now sort of looking and questioning whether in fact they are, or whether the law requires them to do something beyond the rules in the rules on disclosure in the FCA handbook. In the case of motor finance, I'm sure people will have read the news that the FCA are at least planning for a redress process to follow. It feels a little bit like the payment PPI arrangements from several years ago. But I think all of that depends on what the Supreme Court has to say. So I think sort of progress on the redress is probably waiting for the Supreme Court to make its announcements. But I think it's fair to say that the commissions will be sort of high from the agenda. The FCA will look at this and think about whether this is a source of possibly bad outcomes for consumers, and will want to sort of get this get clarity, I think, for the industry above all, but also making sure that customers are not being disadvantaged or given bad outcomes as a result of secret or semi-secret commissions being paid.
Perfect. Thanks, Alan. And I think you kind of touched upon there nicely about the Supreme Court. So it kind of like pulls us on quite nicely to that as the next step. As Ben mentioned, that is starting next week. So there's a lot to come through from that. I think, Ben, I know there's probably kind of questions on a lot of people's minds at the moment is what could be the outcome from the Supreme Court, and how could that shape the market going forward versus what was already been said by the Court of Appeal?
This crystal ball time, always nice to second guess what the Supreme Court might say. We could be returned to the position as it was before the Court of Appeal's decision. So the Court of Appeal said some very interesting things about disclosures being hidden in plain sight, not amounting to enough disclosure to negate secrecy. So the previous position that we could return to was that once a customer has notice of the contents of terms and conditions, then once those terms and conditions have been sort of signed, even if the borrower hasn't read them or been told to read them, that they will have notice of everything that's in them, including a commission disclosure, and that perhaps a fiduciary duty is a much more onerous duty than the disinterested duty. The Court of Appeal says that the fiduciary duty arises as a consequence of and in tandem with the disinterested duty. And so we will hopefully get some clarity on when a disinterested duty arises, when a fiduciary duty arises, and what the difference is between the two of them. We think it's probably unlikely that it's going to be overturned in its entirety. We suspect that the Supreme Court is probably likely to clarify and narrow the findings of the Court of Appeal. And so examples of where that might be the case is that there might only be a disinterested duty or a fiduciary duty where credit is, for example, sold face-to-face, where a broker has has another obvious source of remuneration. So, for example, in the motor dealer context, profit from the sale of the vehicle is the obvious example. And then if the broker is in a particular business, so for example, we could see the Court of Appeal now, the Supreme Court narrowing it simply to motor finance dealerships. That's all potentially open to the Supreme Court.
Great, thanks, Ben. I think that covers off kind of the legal section quite nicely now. I'll just quickly jump into the questions. We've got a question from RC. If the FCA were to review this, given the current context, what good reason could they provide for not insisting commissions are disclosed? Ben or Alan, do you want to try and take that one?
Could I make sure I've understood the question correctly? What grounds would the FCA have of? Could you just repeat?
What good reason could they provide for not insisting commissions are disclosed? So basically, kind of reversing what I assume is what is looking at not making sure that commissions are disclosed. So are we basically has the horse left the stable, so to speak, or is there a way that potentially we get we can see commission disclosures not being done going forward?
Well, I don't know if that question was asked in the narrow scope of motor finance or across the finance industry more generally. But if we take it across the financial industry more generally, I think Ben may disagree, but I think that you need to look at the facts of each case. Look at each individual case. What is the relationship between the broker and the customer, between the lender and the broker? What is being disclosed and what isn't being disclosed? How is credit being made? And if we turn to some of the very salient points in the judgment, as Ben's already alluded to, the brokers in the motor finance industry were doing a double duty. They're operating in a dual capacity. They were both providing cars, selling cars, but also selling. Introducing to credit. If you take some areas of lending, for example, around price comparison websites and people who are looking for unsecured loans on through Compare the Market and so forth, then there is no sort of dual capacity going on. This is purely about loans. There is no suggestion that the broker is getting their remuneration from something other than making the loan service available to customers. Also, they provide a ranked list of offers, and borrowers get to choose. All of that feels very different to what was going on in going on in the motor finance world. So I'm sure that the FCA will draw I hope at any rate that the FCA and indeed the law in the Consumer Court would drive a clear distinction between the motor finance case at one extreme and price comparison websites on the other. Then we also need to think, where does premium finance come in? In that world, I think there are some strong similarities with the motor finance area. You've got the dual capacity going on, providing insurance and making introductions, and it's not clear, I think, whether all brokers are sort of searching for the cheapest or the most advantageous loan to make available to the customer. So there's some very strong similarities there.
Great, thanks, Alan. Ben, did you have anything to say then, or anything to
add? No, not on that question. Just conscious that there are two more come through.
There are two more coming through, but I think we've got a couple of other three other sections to get through, so we might come back to those later. We'll jump into kind of implications for the premium finance sector. I think that's probably why most people have joined the call, and to get a bit of a view around that. And Alan, you kind of touched on quite nicely there around the duality of insurance broking with selling insurance products whilst also doing premium finance, and how that compared likely with car dealers selling cars and also doing finance on the side. Those are obviously two key elements of how those two areas are quite similar, and why we might see some sort of spillover from the motor finance scandal into premium finance. Are there other elements as well that we can potentially see comparisons between the two?
Comparison between the two areas. I think you've got similarly, you may have the questions around how is what disclosures are being made. Is the existence of a commission being made available, and if so, are the amounts being made available? That may vary from broker to broker and case to case. So there'll be probably a range of practice across the industry there.
I suppose within kind of the premium finance space as well, there also is sometimes variable commissions which might change from customer to customer, which probably aligns, Ben, as well with what's happening in the motor finance space.
Yeah, the DIC commission arrangements were banned in 2021, where the sort of the higher the interest rate which the broker got to set, then the more commission that was payable to the broker. Those arrangements have been banned, and yeah, never expect to see them come back again. I don't think that's perhaps a feature of the premium finance world. I suppose in terms of just building on Alan's point, in terms of comparisons, for me, one of the key things is that in the Johnson case, the motor dealers were acting in the capacity of credit brokers. They were caught by the rules in Conc 4.5.3 in relation to commission disclosures, which of course do not require the pounds and pence amount to be set out. And I think from an insurance broker perspective, these brokers will also be credit brokers, and therefore the same analysis at the moment set out by the Court of Appeal will be relevant to insurance brokers, insofar as a result of being a credit broker, the Court of Appeal says that a disinterested duty necessarily follows that, without actually providing any reason for why that is the case. So that's a very important comparison. I suppose distinguishing features is that these three customers went into motor dealerships and were dealt with face to face. Whereas the sale of insurance now, you have much more digitalized journeys, and you can therefore draw a distinction between the actual journey and whether or not a disinterested duty or fiduciary duty ought to arise in circumstances where you have an entirely digital or online journey. And the other piece I think that might be different from a motor context is that insurance brokers can also be paid by the lender for ongoing servicing of credit agreements, so for running account credit, and not all of that commission is paid specifically in respect of the introduction, and perhaps how you might look to analyse the payments sort of slightly differently.
Perfect. Alan, I suppose like looking at brokers going forward, MGAs, how they kind of take learnings from what's happened in the markets. What kind of like proactive measures can premium finance providers, or brokers take as well to enhance transparency and compliance? Maybe Alan, there's one for you.
Sure. Well, the obvious answer is it would be to make disclosures and to ensure that customers give their consent, their informed consent to the arrangements. That there's a number of ways that could be done. Well, one thing the Supreme Court, the Court of Appeal did say is that it's not sufficient to bury the disclosure deep in terms and conditions of the contract and expect that the customer will have read that without having it brought to their attention. So a number of ways you could do it. You can put it in the contract and bring it to the customer's attention. You can have a separate document that notifies it, or as you say, in a digital world, it's very simple. You just to sort of interpolate a simple disclosure and then have a button that allows you to say, yes, I accept. That would be could also be made into a perfectly compliant way. So those are the very practical things you could do to obviate, to reduce the risk going forward. Obviously, you're still left with potentially with a historic, if you have a back book to deal with that. So those are things you could do. If you choose not to disclose, then I think you'd have to be very careful. And here I'd say you need to stick very close to your lawyers and make sure that you're acting on the best advice if you are not disclosing. As I said earlier, I think every case is different, and as Ben alluded to, maybe the Commission is paying for things other than just the introduction.
Thanks, Alan. And I suppose, Ben, from your side of things as well, this kind of is all coming to a head quite quickly with the Supreme Court next week. I'm sure a lot of people on the call are interested in terms of when the fallout might come through. When would this actually impact businesses? I know that there are a number of premium finance companies out there today. There are already disclosure commissions that are going to be paid to brokers, something that's come in after the Court of Appeal. Other businesses have chosen not to do that and are operating standardly as they have done for the last 10, 15, 20 years. So when's the likely is the court's being held next week? When will there be a decision which will allow people to have clarity around what's next?
Yeah, thanks, Chris. So I mean, just building on your first point, we are seeing a range of positions taken in the market. We, without naming any specific names, we have seen premium finance lenders adopting a full disclosure model where there is a pounds and pence disclosure along with a disclosure that describes the relationship or the link between the broker and lender, and therefore as a result of that link the broker is not able to act impartially. And so what that does is almost a dual disclosure whereby you're obtaining the borrower's informed consent to the payment of the commission by the lender to the broker, because you're telling them how much it is and the nature of it, and also sort of at the same time trying to disavow any disinterested duty that is arising by disclosing to the borrower that the broker is unable to act in the best interests of the customer and is preferring its own interests over the interests of the borrower. That's very interesting. We've seen some lenders not do that at all and just proceed on the basis that it's BAU and there's no commission disclosure. In terms of when we will hear, we don't actually know. The hearing is from the 1st to the 3rd of April, and we hope, or industry expects, that the Supreme Court decision will be handed down by the 31st of July. Following that, the FCA has said within 6 weeks of that decision, it will decide on whether or not, based on what the Supreme Court say, there is going to be any sort of redress scheme that it will set up. particular guardrails and rules, which will then require lenders to remediate borrowers that have suffered any loss as a result of that.
Perfect, thanks, Ben. And just building on your point there as well, I think there's going to be a lot of individuals on this call potentially they themselves are not the lender, but potentially worried about any implications or actions that could come back to them. Could there be any kind of remediation work required by brokers or MGAs, or is it just all going to be sat with the kind of the lenders at the end of the day?
No, it may very well be sat with the brokers. It is the brokers that owe the duty, and if there's been a breach of the duty, then the broker is potentially liable for the losses that run from that. So generally the repayment of the commission, where there has been a payment of a bribe because there's been a fully secret commission, then a lender will be primarily liable for that.
Thanks, Ben. We have one question in the chat, which I'll just jump to now. So should insurance brokers / MGAs selling insurance direct to consumers via websites now disclose the commission they receive from insurers? So I suppose this is looking further up the insurance value chain to look at other commissions that are kind of being looked at there. And should the disclosure to the consumer also include all the other commissions or lead generation fees that are effectively out of the total premium the consumer pays?
I mean, at the moment, from a practical perspective, given that the Johnson decision is confined to facts relating to motor finance, it is probably fair to say that commissions paid in respect of motor finance are squarely in the crosshairs of claims management companies and customers making complaints. Our particular view is that the decision is, it's not specifically based on particular FCA rules. It's based on common law principles relating to disclosure of commissions and bribery. And for that reason, we think it probably does have broader application, particularly in relation to, specifically in relation to the question of should you be disclosing commissions payable by insurers to brokers. Based on what it says in Johnson, arguably, yes. However, given how close the Supreme Court hearing is and when we expect we might get the judgment, should everybody go out now and start changing their processes and start making vast ways of disclosures? Probably not. And let's wait and see what the Supreme Court says and how much the Court of Appeal's decision has been narrowed. But on the face of it, yes, you look to the underlying relationship between broker and customer. Do you have a disinterested duty or fiduciary duty? If the answer is yes, then arguably there needs to be a commission disclosure.
Thanks, Ben.
And it's probably, Chris, also worth pointing out that we've got another Court of Appeal decision from 4 days ago. In the case of it's a B2B energy case where commissions were paid in relation to introductions for business premises energy. So completely different industry, but very similar scenarios. Commissions paid for introductions, and the Court of Appeal applied Johnson in that context.
So we could see in the kind of the future as well. Then there's a lot more potential change coming down pipe as we kind of progress with this Johnson as as the kind of the new way forward in terms of how commissions are viewed by the law.
Yeah, exactly. And so that's why the Supreme Court decision here is incredibly important, because it's not just confined to motor finance. We've seen a Court of Appeal apply the Johnson decision in the context of B2B energy introductions, for example.
And will that, a bit more context on that, is that going to be looked at by the Supreme Court as well, that latest incident you just met, or is that just...
No, there was an acknowledgement in the judgment that the Supreme Court will be looking at Johnson on appeal very shortly. But I don't think that's been appealed.
I think that kind of concludes nicely kind of implications of the premium finance sector. So if anyone has any questions, feel free to pop them into the chat. We'll come back to them. Otherwise, we'll kind of jump on to the next section. We kind of talked about briefly around best practice for commission disclosures. Alan's mentioned in terms of what should be done. I think businesses as a whole, there's kind of the insurance broker market, there's kind of two aspects to it, and two angles that very much digital first, which should be quite straightforward in terms of alluding to kind of the price or the cost of the kind of the commission that's going to be paid to the individual. But there is also kind of offline journeys where a lot of kind of insurance business is still done over the phone, and how that kind of commission can be disclosed. It should still continue to be via a kind of a solution where the customer has reference to it at all times to make sure that that is fairly disclosed and pushed through. I think in terms of the number of practices that are happening in the industry at the moment is very variable, as kind of being discussed. I think, Alan, do you want to kind of like touch upon what Render is doing at the moment, how that's why we've decided to opt for that as our kind of method for commission disclosure?
Yeah, sure. So if we look at our main unsecured lending, so not premium finance, look at our Abound lending. This is originated through price comparison websites. We think, that there is a good argument for saying that introductions through price comparison websites are very different to those in the motor finance industry, and that we don't think that I think there's a good case to say that the findings of Johnson, Wrench and Hopcroft don't apply in that case. However, it's possible that somebody might want to argue that it does, and so a safety-first approach is, in fact, to make some disclosures. So we're making disclosures and obtaining consent to the existence of commission and putting a maximum amount around that. So that's for unsecured lending. In premium finance world, I expect we'll be providing disclosure of the similar disclosure for premium finance lending, and making sure that that it is clear to the customer that a commission is being paid, and exactly how much the extent to which we disclose the exact amount, I think will be determined.
Great, thanks, Alan. I suppose looking forward, I mean, we've done a bit of crystal ball stuff already today, but it's always fun to kind of predict what's going to happen in the future. There's obviously going to be a lot of change that's happening within the motor finance space, and there is a view that a lot of this will blow over into premium finance. What regulatory changes should brokers, premium finance companies anticipate in the near future, post the kind of decision from the Supreme Court, and once we have the outcome for that? Ben?
Yeah, so in terms of regulatory changes anticipated in the near future, I think much will depend on unfortunately what the Supreme Court says. HM Treasury, in its intervention application, HMT wasn't successful in intervening in the Johnson decision going up to the Supreme Court. But in its application, it asked for the Supreme Court decision to reflect the regulatory framework, so bringing the common law in line with what the FCA rules say, particularly in Conc 4.5.3, which doesn't require a pounds and pence commission disclosure. But actually, it's possible that the reverse may need to take place. That is, that there's going to be a realignment of the regulatory framework to bring it in line with the Supreme Court's view of the private law position, essentially. And so to that end, what we might see is the FCA consulting on changes to its rules following the Supreme Court decision. And that is absolutely a possibility. And any regulatory realignment may need to go beyond the motor finance industry, depending on where the Supreme Court lands. And so we could be looking at questions that range from questions about dishonesty or unfairness, all the way through to things like customer vulnerability and even the FS sector more broadly, including changes to potentially rules in ICOBs as well. So I think it's fair to say that it's probably all on the table at the moment and very heavily dependent on what the Supreme Court say.
Yeah, I think it kind of leads quite nicely. I think there was a lot of changes last year around what the FCA, how they viewed premium finance, and that is kind of like shown more forthfully through the fact that the FCA launched a market study into premium finance industry as well. How might the two intersect over the next 6-9 months to kind of like for the FCA to decide how they're going to look at premium finance going forward? Alan, maybe one for you. So the question is, how would the premium finance market study and the commission disclosures piece all kind of come together? Big topic.
Well, I don't know is the short answer to that question, I'm afraid, Chris, as you might expect. But I think the review in premium finance is going to take a probably look at the competitive pressures and look above all at how consumers are being served by that process. Specifically in the area of commissions, I think they want to focus, on conflicts of interest that give rise to that, and the extent to which they can be they impact on the service that's being provided to consumers, and obviously preemptive commissions has at least some bearing on that. Are they going to go and sort of chase people specifically on commissions beyond beyond changing the rules? I don't know. They might see that as simply as Ben said, bringing the rule book into line with the law, and just expect everybody to abide by that. It depends on how far they see this as being a question around, is the extent of consumer detriment and application of the consumer duty, in providing good outcomes to people. So that's a very long way of saying I don't know the answer to that question, Chris, but it'll be interesting to find out.
Super. We've just got 2 final questions as well, and we'll kind of open up the floor for Q&A for the last 10 minutes. So looking kind of, again, probably looking forward, but I know we've kind of discussed around commission disclosures and what companies can do there. What can brokers, MGAs do aside from what's being already provided by their premium finance providers to take steps towards mitigating the risk of legal challenges related to commission disclosures? Ben?
I think we've already touched upon that, and that's disclosing the amount of commission that they're receiving and that the link that they've got to the lender ultimately. And it's quite straightforward. The obligation is on the broker to make that disclosure. The Court of Appeal suggests in a particular paragraph later on in the judgment that actually if a lender wants to avoid accessory liability, then that is a practical problem, and that is solved by the lender making the commission disclosure because it has a contractual ultimately has a contractual relationship with the borrower, and it may very well be best placed to make the disclosure in the lending agreements in relation to the disclosure of the amount of commission, and that's what we've seen. But the lender's doing that to avoid accessory liability or primary liability in the case of a fully secret arguments of fully secret commission as the payer of a bribe. But that's just a matter of practicality. So from a broker's perspective, disclosing the commission.
Perfect. I think that kind of brings us on to a final question, which we have in the chat. So should intermediary firms, such as brokers, expect that lenders will attempt to recoup payments made with respect to broker commissions from them? So could, for example, brokers be paying back the commission that's been paid or if it's deemed secretive, would the kind of the Court of Appeal deem that, or sorry, Supreme Court deem that these have all been happening as secretive payments?
I mean, I think check the terms of your contracts would be my advice. And then it would be for a particular claimant to decide who to bring their claim against, whether or not a broker or a lender has primary liability, or if a lender has accessory liability, then the borrower can choose who to bring a claim against. Typically, what we see is that you bring your claim against whoever you can, and then the person with the deepest pockets tends to settle it. And then you would look to the contractual arrangements that you've got as between the parties to see whether or not, you can get some sort of reimbursement.
Perfect. Thanks, Ben. Great. Before we jump to Q&A, Alan, I'll leave it to both of you two. Do you have any kind of concluding points that you'd like to leave with the group?
I think that how should a humble compliance officer look at this question, look at this issue? Well, I think understanding obviously the legal environment, getting legal advice is important. Understanding the commercial context is going to be important, and also understanding the extent to which the disclosure of commissions is kind of a two-way street. There are some people who benefit from the lack of transparency and might wish to resist that. There's also suggestions that disclosure commissions might go contrary to confidentiality agreements written into between brokers and lenders. So it's quite a thorny area to navigate. From a compliance point of view, from taking a sort of fairly risk-averse view, I'd be pushing for to go down the route of disclosure, possibly maximum disclosure of amount as well, and ensuring that you get the customer consent. If you choose to do something else, just repeat what I said earlier, I'd want to sort of make sure that I had pretty rock solid legal advice in my back pocket to before I went down that before I decided not to go down that track.
I mean, from my perspective, I would say have a plan, because this is high profile. The media spotlight is on this. Martin Lewis from Money Saving Expert sort of had a view on it, and he tends to be sort of the yardstick for consumer morality. So I think have a plan, have a detailed plan. So consider taking advice from your professional advisors as soon as the Supreme Court ruling is handed down. Work out whether or not you need to make any changes to your business model as a result of that. And I think in any event, I would say probably prepare yourself for a higher number than usual of complaints, and have a process for dealing with them to ensure that that doesn't take up a disproportionate amount of time. I think complaints will naturally follow whatever happens with the Supreme Court ruling. And then in respect of the advice, work out whether or not you're caught by the Supreme Court's decision, or whether or not there are some distinguishing features in your business model that you might be able to look to argue that the Supreme Court decision doesn't catch you. And ultimately, have a think about whether or not you need to be speaking with your financial advisors for provisioning. We've seen some of the very large motor finance firms making provision for redress, customer complaints, etc., and that will have necessarily involved discussions with their financial advisors as well.
Perfect. Thanks, Ben. We just have 2 questions now in the chat. I'm just kind of go to those, and then we will suppose conclude for today. So is the issue not around brokers' decision to, let's say, misuse the discretionary commission, especially when they had the option to charge a lower interest rate? However, they didn't put customers' interest first. So I think the question is there is around charging high levels of interest rate, and trying to make money over providing a good customer outcome. Is that kind of what the root cause of this issue is?
Let me take that. I think it depends on the level of the commission that's being paid. If you look at the go to the cases being looked at by the Court of Appeal, the commission in question was in some cases a very high as a proportion of the cost of the credit. So I think around about 70% in one case, and it looks like those commission arrangements do seem to be working quite strongly. You could put prima facie, it looks like they're not really working in the customer's interest. So I think all of us in the who are FCA regulated dealing with consumers are subject to the consumer duty. So I think you have to look at the arrangements you've got in place and judge them from that consumer duty approach. Is a customer getting a good outcome out of this or not?
Thanks, Alan. And then the kind of follow-up question to that was, does this mean that the whole commission regime is going to be under the microscope? How commissions are calculated, how they are paid, why they are paid in conjunction with that work that's being carried out by the broker? Is that?
I mean, insofar as will the entire commissions regime be under the microscope, I think it's fair to say that it probably will be as a result of the Supreme Court decision. I've said before that it's sector and product agnostic, and I think therefore it necessarily will result in commissions, payment and receipt of commissions being under the microscope more generally.
Perfect. And we've got one final question. What should I search to find a simple guide to the judgment to share with partners and colleagues?
I was going to unashamedly copy and paste Osborne Clarke's thoughts on it. Multiple law firms have put out some really good commentary on the Johnson decision. So I would say any kind of summary or précis that has been prepared by any law firm will be a really good read, ours included.
Fantastic. I think that's brought the questions to an end. I think we've got 2 minutes left. So I just want to take it there to say thank you to Alan and to Ben for answering and going through those questions. Hopefully the session was insightful and provided a good overview in terms of how the commission disclosure is going to unravel, how it might impact premium finance, and what brokers, MGAs, premium finance providers should be looking to do to make sure they negate any kind of potential impact back onto themselves. As I mentioned, we're part of Render. We're a supplier of the MGAA. And if you'd like to find out more information from us, you can do so on render.credit. And Ben is part of Osborne Clarke's team. He's popped the link in the chat. So if you would like to reach out to him, his details are available there. I'll hand back over to Alison from the MGA, and thank you very much all for attending and listening.
Yeah, so yes, thank you very much. I just wanted to reinforce again my thanks to Chris for moderating the session, and Ben and Alan for their contribution. So thank you very much. So lots for us to take away and think about, and thank you also to everyone who's attended. I'll be very quick because we only have 1 minute left. So yeah, thank you for your contribution and questions. And just one last quick favour, I am going to pop the link to the survey on the chat again. So if you could click on that before you leave, that would be much appreciated. For any colleagues who weren't able to attend, we will get this recording edited quite quickly and up on our member area and on our YouTube site. So that leaves me to thank everyone for attending, and thank you to our presenters.